The Georgia Supreme Court blocks two third-party presidential candidates from the ballot.
This is Dr. David Shine, and welcome to Business Law 101.
As America approaches the presidential election, last-minute issues related to who will be on the ballots in various states takes on a special urgency. This was a recent case in Georgia reported by the Epoch Times that is a good example. In Georgia, third-party presidential candidates Cornel West, an independent and a very high-profile activist, and Claudia de la Cruz, a socialist, are not qualified to appear on the presidential ballot. This was the unanimous ruling of the Supreme Court of Georgia on September 25. The backstory here is that in response to an earlier administrative ruling that kept the two off the ballot, Georgia's Secretary of State, Brad Raffensperger, a Republican, lowered the signature threshold needed for petitions for ballot access to 7,500. Democrats then appealed, arguing the case that West and de la Cruz failed to qualify to be on the ballots because they were well short of the required number of votes. The Georgia Supreme Court upheld the Democrats' appeal. The concern of the Democrats was the appearance of these two liberal candidates on the ballot might siphon away votes from the Harris-Walz ticket. As a result, Georgia voters will have a choice of four presidential candidates: Democrat Kamala Harris, Republican former President Donald Trump, Libertarian Chase Oliver, and the Green Party's Jill Stein. Cornel West, obviously unhappy with the final ruling, noted that voters could still write him in. De la Cruz complained that the two-party system prevented other candidates from being selected by the voters. At the same time, with crowded ballots and limited voter attention spans, having a minimum number of supporters to appear on a ballot, especially for the presidency, seems reasonable. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.